Hi guys, how is everybody? I'm pretty excited to be talking about the Courtney Clenney case today. Let me know in the chat or the comments if you're on Replay Crew if you've already been following this trial or if it's going to be new to you. I know a lot of the audience here for this channel lately has been focused on the YSL trial, and I'm sure there's some overlap. But if you're new, we're going to give you a quick summary of the Courtney Clenney case. If you're already familiar with the case, but you're not familiar with me talking about this case, we're going to be talking about a defense's motion today, right? So the stuff we're going to see is an argument coming from the defense against the prosecution. And if you haven't watched any of my other content, or really if you have watched my content on Courtney Clenney, you've probably seen me, say, hey, this is actually great for the state, or hey, this is great for the defense. So please, if this is your first time watching something from me on this, don't look at it in a bubble. I took a sneak peek at it. I'm going to say, I don't think that the state is playing fairly here, even though I think it's going to be a huge uphill battle for Courtney Clenney to make her case that the murder that she's charged with was justified. She's putting forth an affirmative defense of self-defense. She also recently filed intent to rely on battered spouse syndrome, which when you rely on a defense like that, you have to bring the evidence for that forward, right? So it's going to be an interesting trial. There is no trial date set. Lots of motion, but it's been spread out across, I don't know, it feels like 2 years and change now. Her Arthur hearing, which is similar to a bond hearing, was back in November of 2020. Just last month, she had a renewed bond motion. She had a hearing for that last month. It was denied again. So really a lot of little things, but it's been spread out for many years here. So if you're new to this case, welcome aboard. I have a whole playlist on this case in the description. I'll try to piece in relevant content as it applies to the purpose of this motion. But if you want to deep dive into the backstory, the evidence, earlier hearings, that playlist has a bunch of stuff put together. A shout out to everyone. I see a ton of people from the YSL crew here. So hey to Asia Mullen, to Kristen, to Black Butterfly, to Ghost. Good to see you, Ghost. You've been here for back in the day on this channel. And thank you guys in the chat for all the love and the feedback on the interview with Juror 409 from the YSL trial. That was an interview done on Dennis Byron's channel, but unexpectedly, Dennis invited me up to speak with Juror 409, so thank you in the chat for the positive feedback there. We will have to arrange a separate stream, maybe to talk about more YSL stuff in between the second trial. But good to see everybody piling in here. So, this motion here, if you're new to this case, we've got to learn some names, right? So Courtney Clenney is the defendant. At this point in time, we're just looking at the murder trial. Back in July, there was the separate case. You guys probably heard the news. There was a separate case relating to a laptop that allegedly, one party said belonged to Christian Obumseli. Another party said it was a laptop that was shared between the two, so it wouldn't have been unreasonable for Courtney Clenney to have access to it. But perhaps more importantly than the question of who had access rights to that laptop is the search procedure and the warrants that the state prosecutors filed for to get access to the parents' iCloud accounts. Now, when they get the parents' iCloud accounts, we end up seeing that warrants are issued for the parents' arrest. Clenney is named as a co-defendant, so really the charges were against all three of them, but Courtney Clenney was already in custody. But Deb and Kim Clenney get arrested, right? They get a really powerful, well-respected attorney, Jude Faccidomo. Last year, he was vice president of Factual, which is, we've heard a lot about GACTL, the Georgia Association of Criminal Defense Lawyers, in the YSL trial and how they showed up for Brian Steele when he was held in contempt. But here in Florida, I live in Florida, you guys, there's something similar here for Florida, right? So the attorney that stepped up, and he's still working on an appeal for certain issues relating to the laptop charges and the parents' devices. The state still has property that belongs to the parents, but judge ruled against turning it back over. Jude Faccidomo, big player here, and made a lot of motion over in that laptop case. They argued that going through the search warrant was an overreach, it was too expansive, and then on top of it, the state failed to filter the information, to properly direct their taint team. And in the course of what they were doing, they ended up violating attorney-client privilege and looking at work product that's being used in the defense of Courtney Clenney in the homicide case. So the defense back in June had filed a motion to exclude all of the stuff, get it suppressed, it can't come in, because the state messed up. And Judge Laura Sheeran Cruz agreed. She agreed after hearing a lot of arguments. There isn't a full stream of that hearing online. The only thing that exists from it, as far as video that I can find, we started in the middle of the stream. And it was a horrible quality, but it is linked in the description. It's a bit hard to hear. But Clenney's defense attorney, Frank Prieto, takes a stand. It was an exciting hearing if you can get through watching it with a low quality. But after the judge said, all right, I'm going to grant the defense's motion to exclude all this stuff, guess what happens? Well, you're excluding all the stuff that gave you the basis for the unauthorized access to the laptop. Those were the charges at heart. So you don't have the evidence anymore, so guess what happens? The state has to file a motion to dismiss, and the same day that they filed this, judge closes the case. So that's why you don't hear any more news about the laptop charges. That's closed. It was dismissed. So we're back to the remaining, and we can look at the docket here so you can get a time frame of the dates. If we go back to the murder trial, we have a hearing coming up this Friday. So let's see. Oh, they actually do have a second hearing tomorrow. I don't think we can look at that because it's going to be to determine confidentiality, so probably won't stream that. But there is, let's see, the 13th. Let me get the date right. Yes, this Friday. There might be a hearing. There might be some oral arguments relating to the motion we're going to read today. I'm not sure if there's going to be a camera in the courtroom, but this motion will give us a good idea of what's going to be argued by the defense and what the state will have to respond to. So that's our timeline, and no, we do not have a trial date. So a lot going on here. Let's get into the meat and potatoes of it all. This is also, we heard a lot about the 11th Circuit in the YSL trial. I believe, if I'm not mistaken, Georgia's part of the 5th Circuit, but used to be part of the 11th Circuit. So sometimes we'd hear, when the attorneys were going back and forth with case law, there was some, previous precedent from the 11th Circuit, right? Because at one point Georgia was part of that. They redistricted it. Not really sure. And Florida and Georgia, they border each other. So if you're not familiar with the geography of the United States, that's how it is. And we heard 11th Circuit case law be referenced quite a bit in the YSL trial. That being said, we still have the same judge. And I think this is important. Judge Laura Cruz presided over all of the laptop stuff. She was the one that said, yeah, it looks like you violated privileged communication. You looked at privileged communications. So I'm going to grant the defense's motion to exclude this stuff. And prosecution has to go, oh, well, now we got to dismiss those charges. Well, this is the same judge being asked to make a new consideration in the murder case relating to the same problem. So, I don't know, kind of sets something up here a little bit. So let's see, motion to compel the deposition of Assistant State Attorney Khalil Quinan. And I love this filing system, like the footnotes are clickable. So look at this. We can click right down to it. And I should make this bigger for you guys. Or let me put myself at the top of the screen. I think I block less at the top. But we get this footnote that at this time, the defense is only moving to compel the deposition of ASA Quinan to discover the extent of the breach into privileged communications. However, it is clear that the communications were forwarded to law enforcement and provided to other members of the prosecution team and among other known and unknown assistant state attorneys not assigned to this case. So this is the big fish, right? Back in, I think it was August of this year, because of all this privilege stuff and the motion from the hearing with the laptop charges, the defense did file a motion to disqualify the state attorney's office from prosecuting this case because of the privilege violations. But now this seems like final crunch time. They're really going to make this argument, and they're saying that it's worse than we thought. By the way, guys, a deposition is, it's like a formal setting. Both parties will typically have an attorney present. The party of the moving party doesn't have to have counsel. They don't have to be present. Their counsel could be present. But when someone's being deposed, it's essentially, you're supposed to be telling the truth. You are under oath. And you're going to be questioned back and forth. And it's, I don't want to say it's informal, but unlike if the same witness were to be put on the stand during trial, you would see objections be made in real time and a judge weigh on those objections right away. So if they say objection, lack of foundation, and the judge sustains it, well, now that attorney right then and there has to lay the foundation. But during a deposition, just as general information, the parties might make an objection, but the questions can continue. And if we need to bring in parts of those depositions for any reason in the future, at that point in time, we might want to look at what the objections were and see if the answers can come in or not. Really, when I watch depositions, the main thing that hits the pause button is when someone's about to spill some privileged information. So, and of course, pleading the fifth. So with depositions, I don't want to say they're informal because they're not informal, but a lot more can be said on the record during a deposition than might be said in court. So let's see. Comes now the defendant, Courtney Clenney, by and through undersigned counsels, and respectfully moves this honorable court for an order allowing for the deposition of Assistant State Attorney Khalil Quinan, pursuant to Florida Rules of Criminal Procedure 3-220F. As grounds, the defendant states the following: procedural and factual history. And I think it's also, I'm not trying to treat this as a 101, but I think it's important to state when you read like statement of facts or factual history, it's not saying proven or agreed upon facts by a trier of fact, like a judge or a jury. This is just a formal way of saying we're laying out the pieces for you here, the facts that we're alleging, right? So factual history does not mean a jury has agreed that these facts are proven, right? But at the same time, in motions like this, the attorneys do have rules of conduct. They're not just supposed to come in here and do unethical things like blatantly lie or misrepresent. So just a note there on factual history. So 1, Courtney Clenney was charged by information with second-degree murder and was arrested on August 4th, 2022. That's how long it was. That's how long it's been. The murder here in connection with the death of Christian Opumcelli, which occurred on April 3rd, 2022. Attorney Frank Prieto was promptly retained by the Clenney family to represent Courtney Clenney, as well as protect the interests of Kim and Deborah Clenney. These are the parents. This oral agreement was later formalized in a written retainer agreement dated September 15th, 2022, covering attorneys Frank Prieto, Sabrina Puglisi, and Diane Karamis. The state of Florida is represented by assistant state attorneys. We're going to say ASAs from this point forward: Khalil Quinan, Sean Abahoff, and Kathleen Hogue. On November 3rd, 2023, the City of Miami Police Department obtained and executed a warrant for the iCloud accounts of Courtney Clenney's parents, Kim and Deborah Clenney. The warrant was almost identical to one initially issued in March of 2023, which had since gone stale. The warrant application sought access to the entire iCloud accounts of the parents from November 2020 to present, extending to March 2023. Law enforcement requested access to the entire iCloud accounts. This included data from 17 months prior to the April 3rd, 2022 incident, and data from 7 months after Courtney Clenney's incarceration, when she didn't have access to a cellular phone to communicate telephonically, by email, by text, or otherwise. As a consequence, I see a lot of waves. Hi, everyone. How are you guys? I just see a spam of pink in here in the chat. Did we get a raid? Good to see everybody. Hey, Amy, good to see you. Hey to Jennifer, thanks for the kind words. Let's see. Look at all the waves here. Good to see you guys. I see Diggy, good to see you. Using the Luigi emoji. On StreamYard, it doesn't give me the Luigi Mario Kart picture, it just says Luigi. And that's an interesting name to use today. Let's see here. As a consequence of the information obtained by this overly broad warrant, law enforcement accessed privileged communications between attorneys Frank Prieto and Sabrina Puglisi and their clients, Kim and Deborah Clenney, which occurred after Courtney Clenney's incarceration. These communications took place in a group text called Team Courtney. Now, this is where that infamous conversation with Dad, so that's Kim Clenney. Kim Clenney is the dad. And I believe Frank Prieto were the ones going back and forth. They were trying to figure out the PIN code, the password or PIN code to get onto this laptop. The parents obtained the laptop after the police gave them the okay to go in the penthouse apartment, clear it out, whatever. And they have this laptop, but they can't get into it. And apparently they were trying to get into it. And you might remember this conversation if you've been following it. They were trying a bunch of passwords or PIN numbers that I think Sabrina was able to get when she met face-to-face to visit Clenney in the jail. And we get this text message from Dad to the group chat that says, that one worked! So they found the one that worked. And the PIN number ended up being a combination like month and day of Christian Obumseli's birthday. So, you know, there's that. That's the famous conversation. But in this group chat, they have the attorneys, their paralegal, an investigator, and the parents, Kim and Deborah Clenney. Prior to the search, Mr. Quinan reached out to undersigned counsel to ascertain what emails or numbers needed to be provided to law enforcement with respect to the extraction of, and this is bolded, Miss Courtney Clenney's mobile phone. So, before we do this search, the guy in question here, ASA Khalil Quinan, asks us, he initiates this conversation, he makes this ask, and he says, look, I need this stuff to provide to law enforcement when we do this extraction of a hard device, a mobile phone, specifically belonging to Courtney Clenney. So what happens? Understanding that this would be for a search involving the physical phone, undersigned counsel gave his name, his paralegal, and investigator. No mention was made of Miss Puglisi or Miss Karamis as Miss Clenney's attorneys because there were no communications with Miss Clenney that would be in her physical phone. Now, this is important because this is kind of like, you know, we got to filter out communications from or to these parties. So we're giving you this list with respect to the hard device that Courtney Clenney hasn't been able to use, and thus we wouldn't think to tell you, hey, you should filter out anything that involves Miss Puglisi as a from or to name as a party, or Miss Karamis. But that's not the way it was worked. And this is bolded here. This is bolded here. Neither law enforcement nor the state attorney's office requested the names of individuals subject to privilege for the iCloud of Courtney Clenney or her parents pertaining to a time period after the incarceration of Miss Clenney. No filter protocol was established to prevent the review of attorney-client or work product privileged communications. Now, attorney-client, just to expand here, stuff, I think like common sense, I think a lot of people are familiar that privilege protects, let's say, we're going to use, Dolly talks in the chat. Yeah, you're going to save her, Dolly. I'm going to use Dolly as an example. So let's say Dolly's my attorney and we're having communications. We're talking about my case, right? Common sense, everyone can kind of tell that's probably attorney-client privilege, right? But attorney-client privilege, things that are privileged might not necessarily have to be a conversation between Dolly and myself. If there is a conversation that's expected to be confidential in the furtherance of my defense, right? So if you're speaking with my mom to further our defense strategy, and I'm not directly part of that conversation, it could still be privileged communications. It could be considered work product. There could be tons of different things that the opposition party here, in this case, the state, which is a government body, shouldn't just be able to willy-nilly go and sort through and look at. So district attorney's offices, state attorney's offices have filter teams or taint teams, and they're supposed to filter this stuff out. So, and there's an extra layer here, right? Because there ends up being at some point in time, not just a verbal agreement, but then a written agreement where the parents also retained these attorneys. So they get another blanket of privilege over them. Consequently, privileged communications were reviewed by both law enforcement and the state attorney's office. ASA Khalil Quinan conducted a search of the iCloud accounts and discovered the quote Team Courtney communications. The content of the Team Courtney chat involved discussions regarding all matters related to Courtney Clenney's case, including communication regarding case investigation, witness testimony, defense witnesses, expert witnesses, financial obligations, defense theories, counsel's thoughts and impressions, and opinions on the case. These were communications that the parties believed to be private and privileged. So an expectation that Khalil Quinan is not just going to be googly-eyed in here. On June 26, 2024, the court entered an order granting a motion to exclude. So this is the other case, guys, that we looked at before we started reading this motion. This is the laptop case. And this is the same judge. The same judge made this ruling that we're about to talk about here in paragraph 11. On June 26, 2024, the court entered an order granting a motion to exclude and or suppress filed in case numbers F24, 2015A, B, and C. This is a laptop case. The order found that the communications reviewed by the ASAs and law enforcement were privileged as attorney-client and or work product communications. So Judge Sharon Cruz has already said, yeah, you did an oopsie, Khalil Quinan, you did an oopsie. On August 20th, 2024, the defense filed a motion to disqualify the Miami-Dade State Attorney's Office. Now, I don't think they state this in this motion. I tried to look before we went live. But you may have seen me last week say, hey, there was a bit of something interesting happening at a status hearing that took place on Friday that just passed, so 3 days ago. I saw this motion to compel the deposition of Khalil Quinan. I was like, ooh, that's going to be spicy. Definitely not every day that a defendant is trying to depose a prosecutor or vice versa. Again, that might seem like it's common if you're coming over from the YSL trial. But it's not a small ask. It's a pretty extraordinary ask. And so I saw that. I'm like, oh, that's going to be interesting. Oral arguments there are slated for this Friday. We'll watch it if we can. But at that status hearing, there was a news report from a local outlet. It was a small little blurb, but they did mention that the judge kind of nudged the defense on, what's going on with your motion to disqualify the state attorney's office. So it seems like judge wants to make a ruling on that because you can't proceed with the trial until you make a ruling on that. But they need these depositions. So got a timeline here. The general basis for the motion to disqualify is the state attorney's office access to privileged information. In parentheses here, attorney-client and work product. So 2 different types of privilege violations. ASA Quinan's position in pleadings and during hearings has been that he only saw, guys, this is important. His position, Khalil Quinan, is that he only saw one text communication regarding the laptop that he immediately ceased review of. He stopped looking at those records and did not review anything additional. The defense recently became aware, and let's go back over here to this docket, you guys. So, we're going to get names, I'm assuming, further in this, but recently became aware. This is why it's taking time for them to get through with this motion to disqualify. We have these, if we do a keyword search here real quick, notice of taking deposition, and a lot of these are continued deposition by communication technology. So we don't get the names of who's being deposed, but if you look, these are, these seem like they could be in the time frame between this motion to disqualify and the movement that we're getting finally now to say, look, we need to depose the state prosecutor. So I think this time that we've been waiting in limbo, no updates on this case, were because the defense were trying to depose team members from the prosecutor's office taint team. So I would imagine that's why we recently became aware, right? Something from these depositions. We recently became aware that Mr. Quinan, through his review of the iCloud account belonging to Deborah Clenney, accessed an email, and there's a footnote. The email with attachment will be an exhibit for this court to consider as protecting the contents of the document titled Courtney Checklist of Things to Do - Privileged is necessary to prevent a serious and imminent threat to the fair, impartial, and orderly administration of justice. So they're not attaching this exhibit on this motion because I'm a member of the public. We have rights to certain access. Florida is really great as far as transparency. It's awesome. But there's still certain things the parties are arguing over confidentiality of something. So that exhibit is not just attached to this public document. They're going to be arguing that, I think, tomorrow, the confidentiality of it. So, but what do they say? So Quinan, defense just learned that Quinan, while he was reviewing this iCloud account belonging to mom, to Deborah Clenney, accessed an email dated December 22nd, 2022. This is after the oral and the written retainer agreement between the parents and Frank Prieto and his law firm. So this is after all of the umbrellas that would protect in this situation seem to be in place by December 22nd, 2022. And this is after the judge has already found, based on that one little viewing, that the state did violate privileged communications. Now we have more. So this email was from undersigned counsel Sabrina Puglisi to Frank Prieto, Diana Karamis, Manuel Recio, that's their private investigator, Pamela Corvalin, the paralegal, and the parents, Kim and Deborah. The subject of the email was update, and the attachment was titled Courtney Checklist of Things to Do - Privilege document X. Now, they're bolding this, right? But they make a good point here. They make a common sense point. In order to review the attachment, ASA Quinan was required to manually click on the document to open. Right, you get an email. There's an attachment. You might see a little paperclip icon from your email provider next to the title, the subject line of the email. But you usually, as far as I know, you gotta click it, scroll, open the attachment. Sometimes you even have to confirm, do you want to download this? Then once it downloads, your computer may or may not open it automatically, but usually from my email provider, I have to click when the download's complete to either open the download or open the folder that the download's in. So Khalil Quinan, somehow they find out that he must have gone through all of these steps to say, yeah, I want to look at this. So, that's kind of, if this is true, if they have this on good authority, wherever they're saying that the defense recently became aware, this doesn't sound good. This doesn't sound good. The attachment consists of 20 bullet point items of things the defense needs to do in the case to prepare for trial, to include experts to retain, legal research for motions in limine, witnesses to investigate, etc. While some of the items have been filed and are public, like the defense and some expert witnesses, we've been able to look at that stuff, there are other items that have not been made public and are for trial. The email with the attachment searched by ASA Quinan was forwarded to Detective Adrian Perez by Mr. Quinan. Guys, how do you say, oops, I just clicked and downloaded something by accident, and then I also emailed it. I forwarded the email to a specific email address. Oops. And what's crazy here, guys, if you have such a good case, you don't need to play dirty. And if you're coming over from the YSL trial, I think they needed to fill in quite a lot of gaps. Personally, from what I've been able to see, and again, I've seen a lot more of the public information that has been submitted into discovery by the state, which might lean to be more favorable towards the state. Besides the interviews, and I do think that Frank Prieto and Sabrina Puglisi, they've tried to be very public. Courtney Clenney, OnlyFans, Instagram influencer, she is a public figure, and they've tried to make sure that their defense and advocacy for her are public as well. So I'm familiar with what the defense says they have as evidence or plan to do that they're willing to speak about publicly. even though, they haven't filed their discovery for us to look at, right? So I've tried to see both sides, and I personally don't think that the state needs to, nobody should ever play dirty. Nobody should ever be okay with a prosecutor playing dirty. But they also don't need to do a means to an end here, in my opinion, from what I can see. Right? It wouldn't be justified anyway. But if you already have a case, why would you ruin it by doing something that you're not supposed to do? So it's something that I'm very against seeing. It's pissed me off. Like, if you've seen my other content about this subject, you've probably seen it. But like, this is nuts. This is stupid. And this is back and forth between, and they must have a record. My guess is they have a, when you send an email, when you forward an email, it'll say like FWD forward and give you the date that it's forwarded, from who, to whom. So I feel like they're aware of something. They have a basis for this argument. But what's the problem when you don't have that paper trail? Or you don't have attorneys that have the time to fight like this for something? Someone like Khalil Quinan forwarding something to a detective, right? So you're getting more than just a prosecutor, right? This is involving detectives now. They're all playing dirty. You can kind of, if we can't do this research, if we can't find the paper trail, it can just become a finger pointing game. Well, we can't exactly say who violated it, so we can't really say anybody actually did something wrong and use that to disqualify the state attorney's office. It can remain under the rug. We can sweep it back under the rug, right? Just crazy. And that's it, Nam. Habits. So let's see what else they say here. It is the defense's understanding that the resulting documents from any Chapter 119 request made to the state attorney's office in any specific case is sent to the assigned prosecutors. This would mean that ASA Kathleen Hogue and ASA Sean Abahoff have since received a copy of the email titled Courtney Clenney, Courtney Checklist of Things to Do, Privileged document that was accessed and forwarded to law enforcement by ASA Quinan. So the whole gang has this, this privileged document. Detective Perez and Detective Cremacini were deposed in this matter. So there we go. I believe this is why we're getting the defense recently became aware. So Detective Perez and Detective Cremacini were deposed in this matter with regard to their knowledge of the iCloud warrant returns and the data provided to the Miami-Dade State Attorney's Office that included attorney-client privilege materials and work product privilege materials. Their testimony is clear that, and we're getting transcripts, that ASA Quinan had unfettered access to the data, materials, and privilege materials. Their testimony further revealed that ASA Quinan is the only individual who can testify that the materials were reviewed. So question, this looks like a deposition transcript, but it's not saying. Okay, so the next one says deposition of Detective Perez. Is it the same date? Maybe it'll tell us. I think we can probably assume that this is also Detective Perez up here, but it doesn't say. So it starts, question, yeah. You originally said messages is what he said. He discovered messages, but then you used the word message. He saw a message with Obumseli. I just want to make sure I'm clear as to what exactly he saw or told you he saw. Answer. So, first of all, I can't say exactly what he saw or didn't see. All I can say is what was presented to me, and what was presented to me was one particular message that had the name Obumseli and laptop in it, so it had both of these messages in it. I don't remember if it was one message back to back, or if it was on the same message. We are talking about a long time ago, so I can't really specify that. Question. Did he tell you what all he looked at as he was doing his investigation? No, he did not. Were you present while he conducted any kind of investigation? No. Can you say whether he reviewed the entire text communication that you observed? No, I cannot say that. Do you know whether we are referring to Mr. Quinan for all these past questions and the follow-up one? And then it goes to deposition of Detective Perez, pages 18 through 19. Did he say how he came to see the message? You said he gave you some background on how he came to the messages. How did he say that? He didn't specify, no. So you didn't know how he conducted an investigation or how he came upon the message? No, I wasn't there. But he didn't explain it to you either? No. And then we move to page 20 of this deposition of Detective Perez. What specifically did he tell you about that? That the topic of attorney-client privilege had come up, and that he did not apply to this particular case, and that did not apply to this particular case. What? Oh man, you've got your detective just throwing you under the bus. Do your thing, Detective Perez. Not trying to. I'm like, all right, is he being evasive or is he just being forgetful? I get that time bears down on your memory. But oh boy, oh boy. What did he tell you about that? Well, on the topic of attorney-client privilege, he said that did not apply to this particular case. Stop it. Oh, man. Oops. Question. Did he give you any specifics as to who he met or discussed this matter with in his office? No. Did he tell you that he also discussed the matter with any defense counsel? No. And then we go on to page 21. I just want to make sure it is clear with respect to the referral that you received. Do you have any knowledge that anyone other than Mr. Quinan is the one who found the text communication or the written communication? Answer, I don't have any knowledge as to who found what. No. Then we go to page 27. Question, no, my question specifically is, you can see he did something more than just review that one written communication, right? You can see he also searched emails? Answer, I don't know if emails were searched. I don't know where that came from. Question, fair enough. You know that he provided you with an email? Yes. You don't know where he got that email? I do not know, no. You don't know whether he conducted any kind of search, right? I don't know. You don't know how he conducted the search. It says no response. Question, if he conducted a search, you don't know how it was done? No. You don't know if he spoke to anyone in his office about any search he conducted on his own? About a search? No, I don't know. You don't know if he shared any of the results of any of his findings with anyone in his office? No. My understanding is he did confer with his team, whoever that is, I don't know, to make sure it was not a case of privileged information, at which point they made the referral to us. So he did confirm to a certain extent. I don't know specifics as to how that happened. Guys, so we see earlier in this motion, like, we're reading the deposition transcripts that they're inserting in this motion to make their case here, to make their argument. But the defense is like, look, we really want to depose Khalil Quinan. He's the one that would know. And like, he's like the shot caller. He's taken the lead in prosecuting this case. But here, if you find out that Quinan's saying, let's say Quinan's here and I'm like Kathy Hogue and we'll use Dolly talk again. Dolly Sean Abahoff. We're all on this state attorney's office team prosecuting this case. If we find out that in a one-on-one conversation, Khalil Quinan is telling Detective Perez, oh, well, I conferred with them and they told me it wasn't privileged either. Do you know how mad I'm going to be that you're implying that I willy-nilly violated was okay to tell someone, don't filter communications, just go ahead and read it. This isn't an issue of privilege here. Reading a document. Do you want to look at that document name again? The attachment name? Oh, let's look at the nice bolded text. Courtney checklist of things to do. Privileged. Like, oh my gosh. Oh my gosh. So don't throw me under the bus. And I think for the defense attorneys, I think it's slick of them to include this part, right? It's showing that somebody's aware that at least Khalil Quinan was making a conscious decision to say this is not privileged information. Go ahead and look at it. Here, I'm going to forward it to you. But at the same time, I think it's also good strategy. You're kind of like throwing a grenade into the opposition trench, right? Just get them mad at each other. Oh my gosh. This is crazy. This case doesn't... Nem, this is exactly right. Nem says, do they even need all of these info? Do they need to be prowling through this privileged information? That's the question of the day. They have previous videos. crime scenes, the police cam, that's enough. I think the evidence against the self-defense justification is very strong. I think the Clenneys, I think her defense attorneys have a huge uphill battle to convince a jury that what she did was justified. Because again, it's an affirmative defense, right? She's not disputing that she's the one that threw the knife. Oh my gosh. And big shout out to Louisiana Lady. Thank you for the super here. You were amazing last night with 409. I immediately subscribed to your channel. Well, thanks for hopping aboard. That was interesting. I don't, this is in relation to alternate juror 409 from the YSL trial, who has been doing interviews with Dennis Byron. I don't really argue with people. I don't really debate. I like to have conversations. So that was a unique position to be in, right? I'm not normally like on the chopping block, if you will. Plus I wasn't at my computer, so I was like I've never really been on StreamYard on my phone, so it is nice. I'm glad nobody's like, you were unreasonable or you weren't fair. So I appreciate you guys on all the feedback and critique of that appearance there. And glad you hopped over here. The Honorable, yeah, that good to see you, says prosecutor's been playing dirty since the Bible days. Right. And no matter what, I say put it under the lens. And again, I don't think we would have this if this knucklehead detective wasn't just like, oh yeah, I think he was like talking to his office. He told me he was talking to his office. So in a way, shout out to Detective Perez for just saying it out loud. But also, think of the comfortability that ASA Quinan has if he's just forwarding emails with an attachment with the word privilege in it. You could have filtered by the word privilege. Forget not requesting the proper parameters of what you should be filtering for. You could have filtered by the word privilege, and it would have filtered this email out, and you would not have looked at this email. Like, just crazy. And these are things that, again, Courtney Clenney, I don't know what her net worth is currently, but when she brought this case forward, she had millions. She had like at least 3 million to her name, I think, because there was like records that she moved 2 million in some over to her father's account, plus there was still money being closed out, being sent to her before OnlyFans shut her account down. And I mean, in short, my point is she's able to afford to put up this fight. A lot of this would just be under the radar otherwise. Like, just crazy. So, and FFS, oh my god, FFS is out here sniping. Can you guys show FFS some love in the chat, please? Good to see you, FFS. Got 4 boops here in the chat. Big thank you. And you guys know FFS makes it easy to shout him out. Good to see you guys. Good to see Laugh always have fun. Hey to JC. If you're just tuning in, guys, it is worth it, I think, to rewind like 10 minutes, really from when you see us back 2 pages, and just look at what this prosecution seems to be doing. Oh my gosh. So, yeah, Kino says Cali's full of cases like that. Just crazy. Just crazy. And that's the thing, like, for, you know, overlap with the YSL trial, we just had the verdict. We have Max Sharp, we have the jurors, we have Doug Weinstein. We have people on the outside giving their insights on strategy, trial strategy. And from both sides, right? The strategy that the prosecution chose and any changes they made, any play calls they made during the trial, any strategy that the defense attorneys chose or any play calls they made during the course of the trial. The strategy has such a huge impact on outcome. And this checklist, it might not be, okay, we mentioned a specific piece of evidence. You give a hint away to the prosecution what your defense strategy is going to be. That puts you at a disadvantage. It's unfair. It's a violation of your right to put on your defense. A strong defense, a fair defense. So, just a whole mess. Whew. Where were we? We were like here somewhere. Detective Perez is like, yeah, Quinan told me he conferred with his team, whoever that is, I don't know, to make sure it was not a case of privileged information, even though the email says privileged. at which point they made the referral to us. So he did confirm to a certain extent. This just seems like Quinan was being slick to me. This is my opinion. But it seems like Quinan was like, oh, it's fine. Pass it to you so you can go violate. Because I probably looked through it already, and I want to use what's in there. But I want to say that I didn't get it by, fruit of the poisonous tree. I didn't get it by unethical means. I just got it. My detective passed on information to me that they found out somehow in the course of their investigation. Right? It seems like he was trying to move everything over onto Detective Perez's plate so he can claim to not know any better, to be none the wiser of any of this. That's my opinion, but I don't know another more reasonable explanation here. And Detective Perez says, I don't know specifics as to how that happened. You don't know what he would have told them? No. Or what he might have showed them? No. And then they jump to page 38 to 39. I don't recall that email. No. Okay. So up until that date, the only thing on the 27th you saw that you recall are these two reports? Yes. Okay. And so you don't know whether he actually stopped conducting an analysis or not, right? No. I'm not with him, so no, I don't know. I don't know what he did. And you don't know when he uncovered that email from myself to Deborah Clenney? I do not know. And who gave you the opinion that it wasn't privileged? ASA Quinan. This Detective Perez put him on a podcast. Oh my gosh. He's like, oh, I don't know. And then he just spills the names. He names the names. He puts up like one wall and then he gives up. And when you received that information, do you know when he started looking at it? No, I don't. I would imagine somewhat around the same time. Do you know what kind of searches he performed? No. Do you know what he was able to uncover? No. Did you ever have any communication with him about the contents of the messages? What messages? And now we're going to move to deposition of Detective Cremis. Oh, maybe these are underneath. Let's see if... Well, I'm going to scroll to the end of the transcript. Okay, guys. So I think these descriptors of the transcript are following the screenshot above. So that's why we didn't have one at first. So this one that we just looked at, this last little screenshot, maybe that was from Detective Cremasini and not Perez here. This one little chunk here. And so continuing again now with Detective Cremasini. Okay, so you can't say what files he opened. No. You can't say what folders Khalil Quinan opened. I can logically. Obviously, there was a case that came as a result of it. So I would imagine that anything that was discovered is what was, I guess, presented in that case. Oh my gosh. So, and this is, I can logically, obviously, I know he's saying the word obviously, but this still seems like speculation. But it's this detective speculation that there was a causal relationship between this discovery. Oh my God. No wonder they dropped that laptop case, guys. I can't wait to go back and watch that hearing because the way that it was represented to the judge was quite different than this. They said they read one measly text message. So Quinan, or whoever's deposing here, says, okay, so it would seem logical that he would have looked at some things, right? Correct me if I'm wrong, but there was a case that came. This laptop case stemmed from something from the iClouds. Is that, or am I mistaken? No, you're correct. You just don't know exactly all of what Khalil Quinan would have looked at. Is that fair to say? I would logically imagine that anything that was looked at is what was included in that case. Question, I'm more concerned about the privileged material he looked at that was not part of that case. And then Quinan objects. Quinan is here. This is crazy. Why didn't they have somebody else sit in? Oh, he might be there as a party. I wonder if he's named as a party as part of why we want to take this deposition. So he might not be there representing Detective Cremasini. He might be there as a party of his own interest because this deposition is going to be used against him. But what? Imagine you're asking these questions about Quinan and he's the one sitting right there in the room with you. So he objects to form, and Miss Puglisi, I guess, has been doing the questioning here, and now we get a name from the transcriber. So my question is, you don't know all of what he looked at, right? No, I don't have a list. Do you have any personal information about whether or any other prosecutors in the case, Sean Abahoff or Kathleen Hogue, did any searches from that iCloud return? No, none that I'm aware of. Do you know whether Khalil Quinan had any communications with anyone in his office regarding what he discovered from the iCloud warrant returns? Yeah, I mean, I believe generally that obviously is what led to the laptop or computer case. Okay, were you present though? You don't have any personal knowledge as far as being present for any of those communications, right? I was not present, no. Okay, so it's fair to say you believe communications obviously took place, but you can't speak to exactly what was said? Correct. So there we go. That's the end of the transcripts. And I would imagine that there was some cross-examination questioning in these depositions, but again, this is a filing from the defense, so they're putting in what's relevant to make their argument. I didn't see a response filed. Maybe they'll just argue orally on Friday, but if I see a response filed, we can look at that. They might include some other transcripts that show the cross-examination here. I think, did I link this document in the chat, hold on. I'll drop the link, and if it's not in the description, my bad. It's on Twitter already. I already shared it on X. Here it is in the chat, and I'll update the stream when we're done reading through this. Let's see. My bad. And then the legal argument. And this is important because, you know, what supports our ask here? We're asking to depose the lead prosecutor in this case. Taking the deposition of opposing counsel in a pending case is an extraordinary step which will rarely be justified. So the defense is acknowledging, like, this is simple, Your Honor. It's black letter law. It's common sense that you should allow this. They're saying, we know this is a big ask. But State v. Donaldson, that's a Florida case, citing Egan v. DiManio. We're going to cite Olson v. State. We're going to cite, oh my God, there's a ton. West Peninsular Title Co., Palm Beach County. And I'm going to try to ask some attorneys the next time we stream. I'm going to be like, are these like cases that are widely cited, right? If we're able to watch this argument or watch other hearings in Florida, we might start to hear some of these cases over and over. I just don't have a gauge. I'm not familiar with how often or not that they're cited. We have Shelton v. American Motor Corp. However, prosecutors do not stand immune from discovery. So this is all the case that's kind of opposite of their position, right? It should be an extraordinary ask. But prosecutors aren't fully immune. They're not fully immune from discovery. So we're going to cite the case law that tells us when there's an extraordinary situation that warrants an exception. So Egan v. DiManio. So they say, in this case, in the rare case in which the defense believes it has a basis for taking the prosecutor's deposition, the defense must first exhaust less intrusive discovery methods and then make a showing of necessity and materiality, and that the interests of justice require this extraordinary step. On a showing of materiality, the court may require other discovery to the parties as justice may require. This is Florida Rules of Criminal Procedure, so this is a statute. Here, this court has already ruled that the materials reviewed by the state constituted work product and or attorney-client privilege materials. There you go. There you go. The defense is saying, Judge Laura Sharon Cruz, you've already made a ruling. You made a finding that this was a violation of attorney-client privilege and or work product in that laptop case. And it was such a violation that their key evidence, you said, it needs to be excluded. And because you did that, they had to drop their case. Do you think that's a pretty extraordinary circumstance? And again, it's the same judge that made the ruling that caused that tumble down in the laptop case. So she's already familiar. I mean, this puts her in a position like, are you going to change your own mind now that that wasn't a violation? Because you deemed it a violation and it toppled an entire case in a separate matter. And here, I don't think the ask is to drop this case. Remember, the prosecution filed a motion to dismiss the charges. They said, all right, we're not going to bring this laptop case forward anymore. It wasn't like the judge did it on her own. But here what the defense is asking for is just to disqualify these state attorneys from prosecuting this case. Get them off because they've peered through. They know a lot more than they should about how we're going to present our case, and it would be unfair to put our client through a case where the prosecutors have this unfair advantage. So the defense isn't asking for the case just to be dropped, but they are asking for a disqualification of the prosecution team. So that ruling was based upon the knowledge that one text communication was searched. Had the email with attachment titled Courtney Checklist of Things to Do, Privilege, DocX not been disclosed to the third party during a Chapter 119 request, it is unknown if the defense would have learned, right? And that's what we've been saying here, chat, that ASA Quinan, at the very least, has seen the defense's strategy in the case. The full nature and extent of the invasion of the defense camp, get the fiery language going, is unknown and must be determined for this court to rule on the defendant's motion to disqualify the Miami-Dade State Attorney's Office. So, the reason, remember, they filed this motion to disqualify Miami-Dade State Attorney's Office in August. We talked about it earlier, but if you're joining late, judge at a recent status hearing last week or the week before was like, what's going on with that? Let's get that motion to disqualify together. Let's get a move on. But the defense needed to take these steps, right? They needed to take this time to depose Perez and Cremacini, the detectives. Now that they deposed them, they got the information that kind of confirmed what they were looking for. So, the above deposition excerpts make clear that ASA Khalil Quinan is the witness with the most or the only knowledge of what privileged materials were reviewed by the government. And this is important because these detectives are saying kind of over and over, well, he told us he told his team. Perez said he told us he told his team. But they're like, but you weren't there to actually know. And then Cremacini's like, well, I don't know who he told. I just assume that people must have found out because they brought a whole case forward, presumably on that information that he discovered after reading through that stuff, right? So we have it on a good faith basis to say that Quinan was aware. So we got to depose him and not one of the others. We have to depose Khalil Quinan. You can't just let us depose some other substitute and let him willy-nilly stay on the case and deny our motion to disqualify. Court, you've got to let us go through these proper steps. The depositions of Detectives Perez and Cremacini were the least intrusive discovery methods to determine the extent of the breach, but have yielded no results. The interests of justice now require the extraordinary step of taking the deposition of ASA Quinan. ASA Quinan's testimony on the subject is necessary and material to the continued preparation of Ms. Clenney, specifically as it relates to the motion to disqualify the Miami-Dade State Attorney's Office. The interests of justice require the court to allow the defense to take the deposition of ASA Quinan as it relates to his review of privileged materials and invasion of the defense camp. So, based on the sworn testimony of the detectives above, ASA Quinan's own false statements in open court, that's from the hearing, it's linked in the description, indicating that he only reviewed one text message, and his subsequent review of the privileged defense emails, the interests of justice require that he be deposed on these issues. His testimony on these matters is critical to the court's determination of the motion to disqualify the prosecution team and the Miami-Dade State Attorney's Office. Whew! Wherefore, the defendant, Courtney Clenney, respectfully requests that this honorable court enter an order compelling the deposition of Assistant State Attorney Khalil Quinan. Then they sign off. This is from Frank Prieto, who penned this. Guys, and if you're wondering, you know, they're fighting for bond, they want to get their client out, but what would be the advantage of disqualifying the whole attorney's office? Well, we've seen in the interviews that the defense attorneys have done, Frank Prieto and Sabrina Puglisi, they both have mentioned the way that the state has tried to try their case against their client in the public eye, right? And at the same time, and the state really stepped back off of it when they had to make oral arguments, but they did file a bunch of written motions. They requested a gag order against the defense. And I was on their side because the state made it seem like the defense was doing something crazy, coming up with a rumor about the victim out of thin air with no basis. But I found out later I was actually wrong. The defense got what they got about this rumor of Christian Obumseli possibly being abused by a family member. I'm not saying it's verified or true. I don't think that it actually is. I don't think the defense is saying that. But the defense was referring to something they saw in text message phone notes phone notes. They made a reference to it. And because they did that, the state wanted a broad scope gag order. Then when they were pressed on it in court and the defense attorneys were like, we were just referencing this one thing, state backed down and said, okay, we want you to stop talking about that one thing. And the defense was like, okay, that's fine. Right? So, I've changed with new information. I've changed my mind. I think most people are highly critical of the defense attorneys, of the parents, and I've been there too. But when I read a motion like this, like whatever's going on with any individual defendant, I just don't think that a prosecution team should be able, whether it's one prosecutor or a whole team, should be able to do this and then pretend that that's not what they're doing. And I don't really see a viable explanation if he forwarded this email, how it was just, oh, I got an email, but I never looked at it. You know what I mean? So there's that. As far as what's coming up, our next, I will try to look for updates. I don't know if this argument about confidentiality is something that we haven't really gotten cameras in on a lot of these recent hearings. When the case was happening, especially for the bond hearing, like Law and Crime, Court TV, big interest because it's an OnlyFans model. She has a lot of money. It's a sad story. There was a lot of attention, but I think that the time, it spans so much time that there's been a loss of interest. So cameras haven't been in the courtroom anyway, and I really don't think that a motion for confidentiality, the judge would be like, yeah, come on in. But that's going to be on the 10th, so we might be able to see an update on that before this next hearing on Friday, which, if these local news stations are paying attention, I think this is something that they'll be like, yeah, we need a camera in there for this hearing. They want to depose. They want the judge to allow them to order Prosecutor Quinan to sit for a deposition. I do think there's a good chance that the local news stations will get their butts in the courtroom for that. So I'll keep looking at the docket and try to keep you guys updated. But yeah, like, there's just me venting about prosecutors that seem to lack integrity. Let's see what you guys are saying. Let's see. Asia says, I agree, Kat, that he knew what he was doing. Yeah, that one exchange was, that one transcript exchange. Which one was that? It was really the ones with Perez, but just this overall impression that, no, it's fine. It's not a privilege issue, but you be the one that actually looks through it and violates the privilege, and we won't tell anybody that I already opened the email and the document. Oh, boy. Let's see. I think FFS is sniping again. Big thank you to FFS for dropping another sub. Make sure you're saying thank you if you turned green. What am I seeing all these Kirkland Nick, but not Timu Nick? Are they nicknaming you that guy Nick? Melly, again, thank you for asking where to find this document. I'm going to add it to the description right now for replay crew. Edit description. Okay, FFS says, please don't read the messages. They're completely irrelevant. Thanks in advance. Are they privileged, you guys? I won't look at the chat messages. All right, read the motion. All right, so that is now in the description. And again, there is a link to, my Courtney Clenney playlist. There are some mix-ins that aren't from my channel. They're just like other videos I saw and added to the playlist. So speaking for the content I created about Courtney Clenney, it is a mix of, here's a news story, what's going on, let's figure it out, or here's a document, let's look at it, or here's some of the evidence in discovery. If you are new to the case, I do suggest kind of starting with like a top level summary. But if you want to get into the nitty gritty, there are several different videos I've done that are several hours long each, where we go through the notes. And it was kind of important to read this because it doesn't seem like the notes extracted from Courtney's iCloud or her phone. I don't know if it came from the physical, I think it came from her physical phone, but it might have come from her iCloud. Because, like with iCloud, I think Apple users in the chat help me out. But if you were to use your Notes app and you get a new phone, you can sync your old notes onto your new physical device, right? If you choose to do so. So, there's a set of journal notes from Courtney Clenney from her, it said phone extraction, so I do believe it was from the device. I don't think that this is going to get suppressed. That's really the home base of why I say her battle to fight and justify the murder, say that it was in self-defense and it was justifiable use of force. I don't know if she'll get there, because in those messages, she speaks about hitting him, attacking him. It's never really the other way around. And she says that her intent when she does it is to relieve tension. So, kind of hard to levy a defense argument when in notes that you probably didn't expect anyone to ever read, you're writing to yourself like a diary. You say, I gotta stop throwing things at him and I gotta stop hitting at him. Why do I do it? I do it to relieve tension. Your intent isn't to protect yourself. Your intent is to relieve tension when you're upset. So I'm willing to see anything that comes forth. I'm going in with open ears to any new information. But if you want something interesting, and I don't really think I've seen people cover these journal notes. So there's a ton of great content on the investigation on this case and some of the body cam footage. But if you check out that playlist, you'll see some stuff that I haven't really seen anywhere. So just crazy. Aisha Kenya, good to see you. Whew. But yeah, so there's that. Okay, Brooklyn wanted a cookie recipe. Okay, guys, so one of the cookies I made yesterday, you guys may have heard, and I'll share a link to the Juror 409 thing if you want to check that out. Let's get up that channel. I got up there and I was like, I'm sorry, I'm doing Christmas cooking. And Dennis Byron's like, you're cooking now? It's going to be gross by... But that's not what I meant. I'm just like, holiday spirit. I'm making Christmas cookies. I don't plan... They're like almost gone right now. There's like 2 cookies left. But the kind I made yesterday was strawberry box cake mix. 2 eggs, a 1/3 cup of oil. You just mix it all together till it's good. You roll them into a ball, roll it in powdered sugar, and then you bake in the oven at 375 for 13 minutes. Oh my God, they were so good. They're still so soft today, even though they have a little bit of a crisp at the bottom. They're so good. They're so good. And because you're using a box cake, strawberry box cake mix, you don't need to get the exact right ratio of the baking, the leavening agent, the rising agent, because it's in there for you. It's already done. It was so easy. It was so easy. So those are almost done. I was like, next week's going to be chocolate chip cookies, but that might have to happen like Wednesday or Thursday at this point, since those other cookies almost depleted entirely. But really a simple recipe. So let me get this interview for you guys. There are, just so you know, there are 2 other parts where Dennis Byron has had Juror 409 on his show doing interviews. And part of what's being discussed in this interview recalls things that she said in her past interview. So it might be worth doing a rewind on all, but this is the 3rd most recent with 409. So, oh my gosh, Aisha Kenya says we're making chocolate chip banana bread tonight. I love the smell of banana bread, and I love chocolate chips in banana bread. Oh, so good. So good. Thank you, Kimberly, for the kind words. Good to see you hanging out over here. JC from the D's making cannolis. Love that. Love that. You know, another thing that goes well with powdered sugar. Nem says, the elevator video shows very good control. Unless he transformed while drunk or something, that guy was not violent at all. Well, and that's why, you know, if you go back and you see, I reacted to think it was TMZ. I think it was TMZ that did it. There's been a few like Fox, Hulu, a few different interviews. Court TV does a lot of interviews with the defense attorneys. But TMZ had something that they put together where the parents came on board and they released this interview. It was set to be published and air. Coincidentally, it was like after they'd been arrested on these laptop charges, but it was recorded before they were arrested on the laptop charges. So everything that they were saying in the interviews, in retrospect, knowing that they're under arrest right now, was really interesting. But the parents, especially the mom, were trying to justify this elevator video. And to me, it's one of those things, like sometimes you just gotta pick your battles. I watched that video multiple times. I don't see a plausible scenario where she was not the aggressor in that elevator footage video. I just don't see it. So to see, and I know it's a mom, right? There's a lens there. Parents are going to want to see the best in their child, for better or for worse. But if they try to put that argument forth at trial, if they try to really, I think it'll cost them credibility. So I think that might be part of why recently, I think in October was when they, I mean, I could just look at the exact date. Intent. Okay, yeah, so October 7th, this is when they filed the notice of intent to rely on battered spouse syndrome. I think this is strategic. Do I think that this is genuinely the cause? I mean, maybe I'll be convinced when stuff is introduced at trial. And she did add the person who coined battered spouse syndrome to her expert witness list. So we're going to get the person, the originator of battered spouse syndrome, right? They're calling her as an expert witness in this case as they put forth their defense. Do I think it's going to fly? I don't know. But as a strategy, that is one way you could say, hey, jurors, look, we're going to ask questions of this expert witness. They're going to explain how certain things work. And then the defense could get up there and ask some questions where this expert would be able to say, sometimes victims don't act the way you'd expect them to. Sometimes they could seem like the aggressor. But that's because there's a pattern here, right? So how they react in one individual moment, you might not see something that warrants it if you look at it with a narrow time frame, a narrow lens. But when you look at the pattern, you understand that this is something that victims can do. And they're there to explain it. So now I think this elevator video is a huge factor in why they, in October of this year, introduced an intent to rely on battered spouse syndrome. So lots of movement here going. And again, I don't know if I'll be convinced, but it's a strategy they're taking. So Jim Cox says, make some lady fingers, no bakes, pinwheels, etc. Well, so I have a small household and I don't really like go and do all that much, or I don't really have relatives that I bring food to anymore. So that's why I'm like trying to space it out, like one type of cookie at a time. Because if I make multiple types of cookies and then have a giant platter and there's just a handful of people stopping by and visiting, I don't need that many cookies in my life. But I'll have to work in some creative options, something beyond just the classic chocolate chip. Let's see. I think, hold on, are we sniping again? Oh my god, FFS, hold on. So we have 1, 2, 3, 4, and 5 more. Thank you so much, FFS. You're always making me question my counting skills. Guys, you guys are already on it. I'm like, let's show FFS some love. And then I see Laugh Always Have Fun says FFS the big goat. That guy Nick is FFS is being cast as Shooter, starring Mark Wahlberg. And yes, when you guys hear me call something the Funky Bunch, it is a reference to Marky Mark. Let's see. Yeah, Aisha Kenya. So Amber Heard tried to use a similar argument, and I think the credibility of Dawn Hughes was dismantling, like at face value, because she got up in front of the jury and after multiple questions, she kept genderizing it. She didn't use language like, Victims might not act the way that you would expect them to when they are the recipient of abuse, right? They may do things that would surprise you and might make them look like the aggressor, but it's reactionary. She was using language like she, her, women. She was always positioning by default a certain demographic on the victim side, and on the converse, a different group was always the aggressor. And she just kept doing it. She kept repeating it over and over. And when it was the defense's turn to cross, was it Wayne Dennison that did the cross of... I think it might have been Wayne Dennison that did cross-examination of Don Hughes in the Depp trial. I mean, it was so easy for him to walk right up there and go, have you ever, advocated for a male victim of abuse? She just couldn't answer. She didn't have the experience. And if that doesn't scream bias or incomplete or having a lean, where your entire expert opinion is steered in one direction. I mean, that was a blessing. That witness was such a bad call for Heard's team. And, I'm fine with it because I agree with the victory that Johnny Depp was handed in that trial. But boy, I think Don Hughes, their own witness, was incredibly damaging. Let's see. Yeah, there you go. Big mistake. Oh, LaDonna Ames snickerdoodles are so good. They're so good. And I see Drea in here. Hold on. Heck yeah, Drea. So we're speaking of baking. Guys, show some love to Drea. Drea is baker extraordinaire, getting better and better every day. If you notice, she's been in the bushes a lot. She's actually been in the bakery a lot. She has taken on an extremely, extremely important role. Big upgrade. Congratulations to you. Making pastries. Making tons of pastries, which isn't easy. You just heard me say I use box cake mix. 3 ingredients total. 4 if you count the powdered sugar, which is optional. And I'm like, it was great. Well, Drea is actually advanced at what she does. So show some love. She's been really busy, so it's great to have you here, Drea. And really good timing because we're talking about baking cookies for Christmas. So, and then let's see. Oh my gosh, hold on, FFS. We got 1, 2, 3 more boops here from FFS. Big thank you, FFS. But that's it. That's what I've got for Courtney Clenney stuff, you guys. Before we go off into a rabbit hole off topic here, we'll keep this condensed down, but one of these upcoming days, we'll put something together to talk about YSL. I think Avy's trying to get together a panel. I'll get in touch with her and see if she's got that on the block. I know she's been doing a series of interviews with different attorneys in the case, so busy schedule for her, so nothing's locked in. And we're still trying to coordinate with myself, Max Shart, and Doug Weinstein, trying to get a time together where the founder of the Next Level Academy, the Boys Next Level Academy in Atlanta, can get on and speak with us, right? We're going to do some... there's questions that I have that nobody has asked Max or Doug yet that need answers. So we're going to set a block in advance to talk about the trial. And then as soon as we get through those questions, we're going to talk about a solution in the community, something that can help do something for the betterment of Atlanta, of Fulton County. But we didn't want to, Max made a great point. We don't want to mesh, talking about the trial with this great nonprofit organization. We're going to put a barrier in between those two conversations within that one stream. So still trying to schedule that, but hopefully we can do it before Christmas. It's going to be a good time. Other than that, we'll keep the Courtney Clenney stuff here, but I will give updates on Twitter and in a community post if we get an update on this thing tomorrow, right? It might be a small update. We might just see something appear on the docket. We might not see anything at all. But Friday, either we'll look at documents Friday or a stream if somebody actually records. I do think, guys, when there's a trial date and this goes to trial, I think Law and Crime and Court TV will have their cameras in there. I don't think we'll miss out on anything. But if need be, I'm like 2 hours away, so I'll go down there. I will go down there. But there we go. That's our wrap up here. Glad you love coming in here, Miss Lele. And then Balin says, do they have a new trial date? No. So, and this was a great motion. I know you'd probably, let me link to it again. It is in the description, but I do think that you will enjoy this if you haven't looked at this motion, Balin. Like, I don't know how Khalil Quinan's gonna wiggle out of pretending he didn't know what he was doing by opening an email, opening the attachment that says, Courtney Clenney checklist privileged, and then forwarding it to someone in the police department with law enforcement. I don't know how he's gonna wiggle out and say he didn't know what he was doing when he did that. And then 2 detectives throwing him under the bus saying, yeah, he told us there was nothing privileged to worry about. So I think you'll enjoy reading that. Good to know you're 10 minutes away from the courthouse. Well, that's awesome to know in general. If I come down there, would love to hang out with you, talk about law. You have so much insight. But yeah, I think you'll like this motion. But that's no trial date because this is still an in-between, right? This is a motion to compel the deposition of Khalil Quinan. And this is a necessary step to get all the facts together to consider, for the judge to consider this defense motion to disqualify the prosecution office. So we've got some timelines in the way of setting a trial date. But definitely, guys, thanks for hanging out, especially if you're new to the Courtney Clenney trial. I hope you stick around. Thanks for hitting the like here, Miss Lele. Cha Diggy, telling us what's up. Yeah, I think so too. And actually, are you aware of anybody that has the April 23rd hearing where Frank Prieto took the stand? I have an awful quality. I started a live stream of it. I caught him on the stand, but it was awful quality that day. And I don't see it anywhere else. But I think that was really interesting to watch. So, and honestly, it was really nice to hear. I think that's the most the public has heard from the defense side in this case. So really interesting, but I can't find a good quality video full stream from that day, which really sucks. Thank you. This would be awesome. And if that's available, we can do a rewatch. And if you ever wanted to come up, you can. I know there's some people that have covered, since we've kind of watched it, we could do like a panel reaction and do a rewatch. This is awesome. Big thank you here. Guys, show Balin some love in the chat, and then we're going to close it out. Again, any updates, I'll either go live on Friday, but smaller updates, check X, check the community posts, and show Balin some love on the way out. And you guys all have, hold on, wait, there's Club Classy tonight, you guys. So, and I'm requesting, Shannon Stillwell has released, he put Lizard Walk on YouTube and Spotify. So I told Club Classy that's my song request for the night, Classy Beats. So let me get that link. That's going to be starting in about an hour and a half. But get to the club early. Get the drink specials. All right, so Club Classy in the chat. If you guys are on Replay Crew and want to join us, just search for Classy Beats. You'll find him. There you go. Thanks for showing love to Balin. See you guys over at Club Classy if you can make it tonight. And for those of you overseas going to sleep like Drea, enjoy your night. See you next time, you guys. Bye.